The war on corruption in Kenya has just hit a legal landmine. Barely 2 days after President William Ruto unveiled a powerful multi-agency anti-graft team, the High Court has suspended it in its entirety. At the heart of the battle, 4 petitioners who argue the president has stepped into unconstitutional territory, undermining existing institutions and creating a shadow force at State House. Today, we unpack the ruling, the politics, and the constitutional questions that could decide the fate of Ruto's anti-corruption agenda.
Going forward, si tunataka tukubaliane, si we are one team. Yes, there are people who are destroying the credibility of Parliament.
On Wednesday, Justice Bahati Mwamuye issued conservatory orders stopping the implementation of the multi-agency team on the war against corruption. This decision came after activist Dr. Magare Gikenyi, Eliud Karanja Matindi, Philemon Abuga Nyakundi, and Dinshon Keroti Mogire challenged its legality. The suspension means the new body, meant to unite NIS, EACC, DCI, CBK, FRC, ARA, KRA, ODPP, PPRA, and more, cannot proceed with operations until the case is heard and determined. The mentioned date is set for September 9, 2025. President Ruto's vision was to create a, quote, whole of government strategy, consolidating intelligence, investigation, prosecution, and regulatory agencies into one coordinated command. The Executive Office of the President would chair it, while the Attorney General's office would serve as secretariat. Funding would come from existing budgets, supplemented controversially by other sources. But the petitioners say this structure violates the Constitution. Their argument is straightforward. Article 79 of Kenyan Constitution vests the anti-corruption mandate squarely in the EACC. Article 157 grants independence to the ODPP. Article 231 secures the autonomy of the Central Bank of Kenya. By placing these bodies under a presidentially controlled umbrella, MAT-WAC risk eroding their independence and creating a, quote, parallel government on matters corruption. The bigger question is, can executive lawfully supervise bodies meant to check its own excesses? This is not just about corruption, it's about power. If EACC answers to State House, who then holds State House accountable? If ODPP's prosecutions are coordinated at the presidency, does that blur the line between impartial justice and political vendetta? The activists also flagged the financing model. By allowing MAT-WAC to tap unspecified, quote, other sources of funding, the team risks operating outside the safeguards of parliamentary oversight. In Kenya, where procurement scandals and shadow financing have historically fueled graft, this concern cannot be ignored. Behind the legal arguments lies a political story. President Ruto has recently doubled down on corruption rhetoric, threatening arrests of members of parliament and calling out graft in parliament and judiciary. Critics see MAT-WAC as a political tool, giving State House a direct handle over corruption cases. Supporters, however, argue that Kenya's anti-graft war has been fragmented for too long, and a unified front is overdue.
And they are collecting money in the name of Parliament. And some of the time, or most of the time, that money never gets to Parliament, it gets to a few people. We are not going to shame them. We are going to arrest them. Yes. Do we agree? Do we agree? Yes, whoever is giving and whoever is being given and whoever is doing whatever it is, we sort them out. Because the reality, friends, the reality is that there is a problem. And we all know here, tukitaka tu kusema ukweli, there is a problem. And unless we sort it out, we are going to destroy our nation. We are going to destroy this nation unless we sort it out. And we must be as candid to ourselves here as we are candid in implementing what is transformational for Kenya.
Justice Mumuyi's ruling to suspend MAT-WAC is therefore not just a procedural pause. It is a signal the judiciary is drawing a line on executive overreach. The respondents have until August 29th to file their case, but for now the multi-agency experiment is frozen.
We are actually doing active investigations on various individuals, and as and when that kind of information is available, we'll share with members of the public, or you'll see the consequences in the various levels of the legal system.
Misuse of CDF, constituency development funds, inflated allowances, payments by various individuals who want themselves to be protected.
Let the president come before a committee of parliament. Let him repeat the things he has been saying in public rallies, the things he has been saying in other places. Let him bring that evidence so that it is processed in accordance with the law. If you know these people, do not be mourning and crying like every other common person. As a consumer of raw intelligence and as a person who can direct the DCI to carry out investigations, please, Kenyans want action. We have had enough talk.
As we head toward the September 9th mention, Kenyans are watching two things. First, whether the courts will uphold the constitution and rein in presidential powers, and second, whether Ruto will find another way to push his anti-graft agenda. One truth remains: corruption is not just about stolen billions, it is about who controls the levers of accountability in Kenya.
We would like to find out, are there specific individuals who are particularly engaged in this, and what can be done, not just to punish the current one, but to stop the whole process completely, so that those people who may have been hiding behind politics, behind patronage, would then have nowhere to hide when we go for them.
And this battle over MAT-WAC is shaping up to be less about graft and more about power. For Maisha TV, I'm William Juma.